Welcome to part 7. This is the final part of the contracts exam crash course. If you've gotten this far and actually watched all the videos, I thank you and I hope you do well. And I promise you could even do better if you went to www.lawbarcoach.com and contacted me so I could help you out individually, which I'd be more than happy to do. But let's move right along here and discuss remedies. Now, the whole point of law, the courts, and contracts is that way you can go to court and receive a remedy, or you might have to defend yourself against having to give out a remedy. Remember, let's think back to the beginning. A contract is a legally enforceable promise. Therefore, the courts are legally enforcing it. And how do they do that? They legally enforce through remedies. Quite often, a law student will start answering an exam question, spot a lot of the issues, make some conclusions, but they never actually discuss what the court will do, what the possible remedies are, and that is a very gaping hole in your exam. Because what kind of lawyer just assesses some of the things and then walks away? No, lawyers actually go through the whole process and receive a remedy. Or that's the goal, or at least they threaten a remedy and they might get a settlement. But you have to be aware of what the possible remedies are if you're going to negotiate a settlement. They break down in between common law remedies and UCC remedies, more or less. But the common law encapsulates a lot of the major issues, so we'll start there. The first thing we'll discuss is that there's a general duty to mitigate damages. I've said it a lot of times, and I write it a lot about how contracts is an economic creation. The state likes when people make promises to each other about exchanging goods, and if they're in consideration of each other, these promises, we want to afford those parties some reliability, that they can enforce those promises later on, because we want an exchange of goods that benefits the economy. And along those lines, mitigating damages is economically efficient. If here's an example. If I hire someone to teach me guitar lessons for $100, they breach. They're not going to teach me guitar lessons. Someone comes along the next day, calls me up and says, I'll teach you guitar for $120. They're just as good of a guitar teacher. And I say, I don't feel like it. Then a month goes by, and the only guitar teacher I can find is for $200. That's inefficient. I'm not going to then sue for the difference between the $200 and $100 lessons, claiming that, I now have to pay $200, you have to pay the difference. No, that's inefficient. I haven't mitigated damages. I need to find the guitar teacher that could do it for the best price. And I gave that up. We want things to be as efficient as possible. There are different types of damages. So essentially what you're going to the court and saying, either there's been a breach or the performance was not done correctly, and as a result, I would like to receive some sort of damages in compensation for what happened. That's why I'm in the court. I'm enforcing the contract. The first and most common is expectancy damages. Expectancy damages refers to what you expect it to happen by making the contract. If I make a contract for you to teach me guitar lessons, I expect that you will teach me guitar lessons, and you expect that I'll pay you a certain amount of money. It's essentially the benefit of the bargain. What were the benefits that we each expected? And if something goes wrong, the courts will try to put us in a position as though we received those benefits, meaning the damages that it would cost to buy a substitute performance. If you were going to teach me guitar lessons and I was going to pay you $100, now I have to pay someone else because you breached. I have to pay them $120. That means you need to give me the $20 difference. There's also certain this concept between reliance and expectancy gets a little mushy here. But so the idea is that it's not just the difference covering, is what you call it, between the $100 to $20 lesson and the $100 lessons, which is 20. There are other things, for instance, losses because I couldn't find a substitute. Imagine that I needed you to teach me a certain song for a recital I had on Friday. You didn't show up that morning to teach me the song. As a result, I couldn't find a substitute that day. That was too short notice, and there's some damages I received because I couldn't play that night. This is not like torts where you take your victim as you find them, the eggshell rule. It's a lot more strict. Again, goes back to economics. These sort of damages are only if it's foreseeable. I can't say, oh, guess what? I was playing in the New York Philharmonic tonight. I never told you about it. I was going to make $100,000 to perform that song. You owe me $100,000. It has to be foreseeable. There has to be some certainty to what you lost. It cannot be mere speculation. This is a bit more rare. So, for instance, if Peyton Manning hired John Elway to give him some football lessons before quarterback lessons before the season, and then Peyton Manning doesn't have a good year, he can't sue John Elway if John Elway didn't show up and then Peyton had a bad year. There's too much speculation. Obviously, that example is kind of silly because John Elway is Peyton Manning's coach, and as of the time I'm making this video, he's having a pretty good year. But the idea is that there needs to be some real foreseeability. Reliance, this is about the opportunity. And relying on something happening. So if you told me that you were going to deliver corn on Tuesday, and I hired my farmhands to be there to receive the corn, and you never showed up, I might sue you because I relied on thinking that you were going to perform, and I had to pay for those guys to be there. This cannot exceed expectancy damages, though. The idea is that this is the limit. The limit of the damages is the benefit of the bargain. So pretty much the time you make the contract, you could be aware of exactly what the contract's worth, and that's what you will be on the hook for. Reliability. Stipulated damages, or when the damages are expressly stated in the contract. If you fail to deliver corn, you owe me $500 in damages. Now, the difference between stipulated, what's hard here is liquidated damages are technically a type of stipulated damages because stipulated just means that it's expressly written in the contract. They're expressly stated in the contract. But more specifically, a stipulated damage is something that specifies the limit of what the damages could be, whereas liquidated specifies the precise amount. You might say, I will not be liable for more than $300 in damages should I breach, whereas a liquidated will say, I will pay you $300 if I breach. For both of these, the courts always think of the public policy concerns. Why? Once again, contracts are economic creations. This is not about penalty. That is in the realm of torts. Liquidated damage, it makes it nice and easy. If they say, oh, if you breach, you pay $500. We don't have to start doing some sort of fact investigation to see what a cost of substitute, market value, losses. This is very complicated. Liquidated makes it easy. It says $500 in the contract you have to pay. The only issue is if it's something egregious. It's far more than the contract is worth. It's oppressive. It's unconscionable. Courts will not permit that. It's not there to be some sort of punitive penalty. It's merely there for convenience. Specific performance is extremely rare. Courts, when it comes to contracts, do not want to force people to do things, for the most part. So if I ask you to give me guitar lessons and you don't do it, a court can't say, no, you're going to go there tomorrow, give him guitar lessons. That would mean the court is forcing you to do something against your will, to say things that against your will. I mean, the free speech concerns, freedom of movement, there are personal privacy. There are a lot of issues with that. So courts will only do that if absolutely necessary. Because it's if you don't give me guitar lessons, they'll say, just hire someone else. Why are we going to force somebody to show up and give you guitar lessons? Hire someone else. The only time they'll do that is when damages are inadequate. And this is if, for instance, an example here would be if you had my pet dog and you said, oh, I'll just pay you the market rate of a dog. And the court might say, well, damages aren't going to do anything. The market rate for a 7-year-old mutt might be $200. I doubt $200 in damages is going to make you whole for not having your dog. Although a specific performance that is more common is a negative injunction, a forbearance, preventing somebody from doing something, as opposed to making them. So if a rock and roll star makes a contract to perform at a certain place on a certain day, the courts, and he breaches, the courts won't force him to perform, but they may prevent him from performing someplace else. Restitution, this is another form of remedy, but this is off the contract. This is not on the contract. These are principles of equity, of fairness. They're not contract principles. It's to recover the value of the benefits conferred. Not the value of the contract, but the value of the benefit. I've said this example before. If I am contracted to build a house for you, I fail in that endeavor, I breach, it's a material breach, but I built a very nice fence for you around your house, or what was going to be your house, I can try to get from you the value of a fence. Because the idea is that next time you get a house built, you don't have to have the next guy build a fence for you. It's already built. That's unfair for you to keep that fence for free. This occurs when the contract is unenforceable or contract damages are inadequate. So now we'll turn to UCC remedies for breach of a contract. There are a couple different scenarios for a breach under UCC. Now remember, the UCC applies for the sale of goods, a thing, not a service. That's the common law. So you can think of it as the seller has to deliver something, the buyer then takes. So let's go into the first problem, potential problem area, is when the seller fails to deliver the goods. But what if the buyer wants the goods and the seller fails to deliver? The buyer wants them. What can he or she do? Under UCC section 2716, you can get specific performance. I said above that specific performance is rare, but that occurs mostly if it's we're having a person do something. But if it's a good, it's really not that big of a deal to say, oh no, you have to hand over the goods. He purchased it, you failed to deliver, they're his goods. You won't always get specific performance, and replevin is another sort of term involved in that. It's using an equitable principle to take possession of an item. You won't always get it. Your best arguments here, it's not automatic. Your best arguments are if, say, the goods are unique or damages are unavailable or inadequate. For instance, if I purchase a specific guitar from a certain year, I get a 1961 Gibson SG that was owned by Dwayne Allman. I paid for it. It's a one-of-a-kind piece, and all of a sudden the seller is not going to deliver it to me because he wants to sell it to another collector who's going to pay more money. It's a very unique item. When I purchased that, it effectively became mine. I mean, not literally because I don't have possession of it, but the idea here is that I should be able to rely on that purchase at the time that we made the contract, and I can go about my business. I don't have to worry that it might be sold to someone else. That would give an unfair advantage to the seller to sell something, then hold on to it to see if he can't get better offers. Now, what if the seller fails to deliver, but the buyer does not want the goods? You can recover anything you've already paid, and you can sue for damages. That's very easy. The buyer doesn't show up. At this point in time, I really don't care. Anything that I paid him, I obviously can get that back. And any damages because he never gave the goods, I can sue for as well. I have a football team. On Friday, I expect a delivery of bobbleheads to sell on Sunday that are specific to that game, let's say. They never show up. Well, I don't want them anymore. They're no good. I am going to sue for whatever I paid them, maybe deposit or down payment, and any damages, some profits that I might have received or something of that nature. Here are the other situations. A seller does deliver the goods, okay, but they're non-conforming. He gives me the bobbleheads on Friday that have the wrong team on them or something of that nature. Now, what if I want to keep the goods? I said, well, they have the wrong team on them, but they are going to play that team potentially sometime in the future. I'll just put them in storage. This isn't convenient, but whatever. I can keep them and sue for damages. After all, they were incorrect. They were wrong. They were non-conforming. Now I have to hold on to them. I don't know how much I'll ever get for them. Let's sue and get damages. What if the buyer does not want the goods? I say, these bobbleheads are for a team they're never even going to play. Or worse, I don't want them. You gave me the wrong goods, and I don't want them. I can reject. As long as I do so with reasonable time and notice. I can't get the bobbleheads, realize they're wrong, sit on them for a month, and then call them up and say, I'm rejecting these. No. You have to take a look at them, a reasonable investigation of the products. And when you reject, the seller can cure if there's still time. So on Friday, I get the shipment and I say, these are wrong. And he says, oh, you know what? I know where the truck is that have the correct ones. I can get them to you by Saturday. The game's on Sunday. We'll be good to go. The seller can also cure if he or she shipped them thinking that they conformed. If, for instance, there's some sort of mix-up with the truck, that's another example of using the same example. He says it made the wrong truck, the boxes, or I gave him a very ambiguous description. He thought he was meeting it. If everything is done under good faith, I can reject, and he can cure if there's still time. The idea for all this is that the UCC wants liberal, flexible policies that allow sellers and buyers that are merchants to be able to deal with each other and make things right and take them back, cure. But ultimately, remember, there has to be perfect tender. There cannot be substantial performance. That's why you can reject if it does not meet perfect tender. What if I receive a good and there's a latent defect? The bobbleheads, they look all right. I take a look at them, but I don't realize that they're using a defective spring. After just a couple of bobbles, they break. There's a latent defect. Here, instead of rejecting them straight up, you're revoking your acceptance because you did accept them, but now you have to revoke your acceptance. That's done under UCC Section 2608. The original acceptance either was premised on a possible cure. He told me, by the way, the springs were wrong, I'll get you better ones, but he never does. Or somehow I should say induced to accept. He induced me to accept when I didn't want to, or I didn't think for whatever reason, they convinced me to. Or there's some difficulty of discovering the defect. Like I said, the springs, it takes a couple shakes, more than just a normal investigation of them. Then you can revoke acceptance. What about the seller's remedies under the UCC? A couple things can happen here. The buyer wrongfully rejects, meaning that was perfect tender, but they rejected. They closed their doors when the truck showed up and said, no, these are wrong, I'm rejecting them, take them back. Or they accept them and they never pay. A couple things here. The seller may withhold delivery of goods if they never got the payment in the first hand, or if they were rejected or they withheld. They can salvage the items, and then after that's over, they sue for damages. They take the bobbleheads, they go sell them to some sporting goods store. They probably only can get 50 cents to the dollar, maybe, in short notice, and they go and sue for damages for the difference. This goes back to mitigating damages. You can't just destroy the bobbleheads and sue for the whole contract value. That would be a waste of resources, a waste of materials that made those bobbleheads. We want those bobbleheads to go back into the economy, and you can sue for damages to recover for whatever you lost out on. Generally speaking, if you salvage or resale, you have to give notice to the buyer that those items are being sold either in a public sale or open market, so they have a chance to buy them if they wish to. If you actually make money, say those bobbleheads, you're able to sell them to somebody who wants to pay you more than you would have sold, you don't have to give that profit away. That's yours to keep. That's the seller's to keep. They can also sue for incidental damages, the cost of reselling them. Now they have to go and find somebody else. How do you get on that market? How do you communicate? How do you then advertisements, new shipping? This is a lost volume. Situation occurs where now those bobbleheads were a unique item, but say that the example of selling corn, you wrongfully reject the corn, I go to the market and I sell the corn. If you think about it, well, maybe I had other corn that I could have sold in that market. Not only did you reject, but now I missed out on a sale entirely. If the item is a fungible item like corn or widgets, you can sue for the profits that you lost out on the sale. And if it's a unique item, I buy an electric guitar that has my name inscribed on it and my face, a picture of my face on the guitar. I reject it. They're never going to get anybody else to buy that thing unless I'm slash. So they can sue for the entire contract price. They don't have to just sue for profits lost or anything like that. And the recovery of damages under UCC, we're still talking about expectancy, reliance, things of that nature. Now we're moving on to rights of third parties. This is getting us near to the end of contracts, the penultimate topic now. Third-party beneficiaries. They are people or groups, corporations, what have you, that are not listed in the contract as either the promisor or the promisee. There's somebody else who's benefiting. They actually may sue for enforcement, if you can believe that. If I hire you to make a painting of my friend and then deliver it to him for his birthday, my friend can sue you if you fail to make the painting and deliver it to him. Because he's an intended beneficiary. He can enforce the contract. The contract does not... It's an open question if that person has to be mentioned expressly. But here are a couple things to take into consideration because the party does have to be an intended beneficiary. They can't be someone who just imagine if there's a restaurant that's going to be installed in a certain neighborhood and there's a contract. And I live in that neighborhood, and I'm very happy that an Italian restaurant is coming into to town. I'm obviously a beneficiary of that agreement, but I'm not an intended beneficiary. They didn't know who I was. But so I can't sue for enforcement under that. It's only if the person is intended, and that's a reasonable definition here. They might be mentioned expressly, or they might not. The performance might be directly made to that party. It depends on maybe the relationship that the parties in the contract have to the beneficiary, or if the beneficiary actually has rights under the contract. This is an open area for argument on your exams. So here are the types of third-party beneficiaries. A creditor, a third-party beneficiary, that is, I owe somebody $1 million. I tell you that I will do certain service for you, and you're going to pay that person the $1 million, so I get off the hook with that obligation. A donee beneficiary is a gift. I'm paying you to make a painting of my friend and to deliver it to my friend. An incidental beneficiary is just a lucky person. Like I was saying, the example of the restaurant in a neighborhood, you're going to benefit, but it's incidental. It's not intended. You're just a lucky person. Enforcing rights under a contract. The third-party beneficiaries can only enforce their rights when they have vested, meaning the right itself has matured. We talked about conditions coming into play. So, for instance, if I said, if this is a stupid example, but when the weather becomes 70 degrees out, then can you make a painting of my friend? I don't know why. Until it hits 70 degrees out, my friend can't sue for the rights because they have not vested. The rights, they may only be able to enforce the rights if the contract states a certain time for that. The intended beneficiary can only enforce his right when ... And another instance is if the party detrimentally relies. Assignment and delegation. This is the final subject in contracts that we'll be discussing. Assignment is the transfer of a right under the contract. Now, beneficiary is slightly different because you're sort of just benefiting from the contract. You're not actually mentioned in the contract itself. And your rights to enforce are limited. Whereas, because it only can happen when it's vested or when the contract might limit that and so forth. Whereas an assignment actually transfers the right, legally speaking. You now step into the shoes of the party who was originally going to receive performance. What do I mean by that? If I make a contract to mow Bill's lawn, Bill might then assign his right to Steve, and now I have to mow Steve's lawn. Here's the terminology. The promisor is the person who does the promise. The promisee is the person who benefits from the promise. But now we add this. The promisee assigns the promise. He's the assignor, and he assigns that to the assignee. If we look at the relationship from the assignee, there's the obligor, who is the same thing as the promisor. But the reason why it's called this in this instance is because he's obliging the right to be transferred. We're talking about this now just sheerly in terms of the assignment. The obligor, the right, what he's doing, his promise, is now to somebody else, and the assigner has changed the right, and the assignee receives it. The promisor is the same person as the obligor. The promisee is now the assignor because he's giving away that assignment, and that assigner gives it to the assignee. There are a couple exceptions to assignment. And for one, you cannot do it if you substantially are changing the contract. If I'm going to mow Bill's yard, and he says, I've assigned it to Steve, he lives around the block, all right, fine. But if Bill lives in California and he assigns the contract to Steve, who lives in New Jersey, that is ridiculous. They've changed the duties substantially. Same thing as if somehow it entailed more risks. I don't know, maybe one of them lives on top of a mountain, I have to do it on the side of the cliff. I don't know, but the idea is that risks have to be incorporated in the price of the contract. So if you're signing it after the fact, you're undermining the legitimacy of the bargained for exchange. If the terms of the contract don't allow the assignment, and many don't, leases sometimes don't allow that, or if the statute doesn't allow that. Think of an example. I don't know, maybe you get a pension and now I want to assign the rights of my pension to somebody else. Maybe my state says I'm not allowed to do that. Assignments have to be in writing. The statute of frauds applies. The idea being that this is ripe for fraud. Someone says that, it was assigned to me. And they want to go to court and now receive the benefit of something that they weren't even involved with in the first place. No, you need a writing, and it has to clearly indicate that there was indeed an assignment. Consideration is not required for an assignment. You can just go ahead and assign something. The idea is that you're just changing the destination of the promise. You're not creating a new promise. That's why you don't need fresh consideration like you do with a modification to a contract under common law. Instead, you're just changing the destination of the promise and the performance. But if there is consideration, it makes it irrevocable. If Bill assigns to Steve the right to get his lawn mowed, he can revoke that before performance has occurred. But if Steve said, I'll pay you $10 if you assign to me, then he can't revoke because they've made a contract. In one sense, he's stopped from doing it because because they made a contract. Another example is if Steve detrimentally relied and that was foreseeable, then Bill's stopped from revoking. Just to be a little more clear on that, I apologize. If there is consideration, you cannot revoke the assignment because that's essentially been a contract. Steve says, I will pay you $10 to assign your rights. They shake, they hand the money over, done, contract. If there is no consideration, it may be revoked, but only before performance has occurred and only as long as the person did not detrimentally rely and that reliance must have been foreseeable. All right, good luck.